On this morning's Ag Issues program, as always, a pleasure to bring on to the program Roger McEowen, who is professor of agricultural law and taxation at the Washburn University School of Law, and he joins us on the program this morning. Roger, how are you this morning?
I'm fine, Greg. Thanks for having me on this morning.
Well, and as always, we have a lot to talk about, so let's get right to it. And, you know, Roger, there's a situation out there, and any farmer and rancher can tell you that they experience maybe damages to trees as a result of someone else's conduct. And, you know, this can come from aerial spray drift, excess or maybe even wrongful water drainage from an adjacent tract or other occurrences that are going to take place. But one of the things you wrote about is how do you compute tree damage, or how is that loss measured if you suffered tree damage?
Yeah, and that's actually, it's kind of a complex issue. It really depends on what type of trees we're talking about here and whether we can prove the extent of the damage. Keep in mind, it could be a producing orchard, or it could be a windbreak that's designed to minimize soil loss or protect buildings, or it could be just simply ornamental trees and bushes that provide some type of aesthetic benefit. So I think where we start with the analysis on these types of things is whether we actually have production from the trees. Are we talking peach trees? Are we talking an orchard? Or are these oranges if we're down south or out in California or in Florida? But you know, around here, what we're going to get perhaps on the production side of things would be in the southeast corner of the state. You could get pecans. Over in Missouri, you get peaches, maybe a few vineyards here and there. But likely what you're going to see most of the time in Kansas would be a windbreak that is protecting the soil from erosion. It's providing a benefit to buildings. Or it simply could be very tall, mature trees that are providing shade for cattle and other livestock, as well as that aesthetic benefit. And then you get into really tricky issues. Well, if I lose those trees, what do I recover if the other party is negligent? Well, the first thing that requires is that we have to go through a negligence analysis, and that requires that the plaintiff that's been damaged to prove four elements. It's like links in a chain. You have to prove that you did have damage, that the other party caused the damage, that there was approximate causation between what the other party did and what resulted. So they have to have acted in a certain way that breaches the normal standard of what we would think would be reasonable conduct. So if we're talking about an aerial crop duster, what would be a breach of a standard for an aerial crop duster? Well, maybe that's flying when the wind is out of the wrong direction, or too high of a wind speed, or they just didn't shut it off at an appropriate time and just got to the edge of the field and kept spraying and sprayed your trees. You know, that's that type of negligent conduct. But assuming that you can prove duty, breach, causation, and damages, then you get into calculation of the damages and the computation of it. And Greg, that's as I said, that's the really tricky part of this.
There are, and you cited actually a recent case, as a matter of fact, in this that occurred, and it was specifically the plaintiff. He had owned a ranch, or they had owned a ranch, used for commercial hunting purposes.
Yeah, and this is a Kansas case. It came down last year. So it's just a few months old, but the ranch had a row of hedge trees about 20 yards wide and 300 yards long adjacent to the defendant's property, and they were mature trees. Now this didn't result as problems associated with aerial crop dusting, but the defendant's tenant contacts the plaintiff and wants permission to cut down the hedgerow and install a fence, and the plaintiff said, "No, don't cut my trees down, don't disturb the vegetation." But the defendant's tenant went ahead and did that, cut the hedgerow down, installed a fence, and destroyed 156 mature trees in the process. So the plaintiff's upset about this and sued, claiming a whole bunch of things, negligence and conversion and trespass, saying that the loss of the trees decreased the value of his property for hunting purposes. Keep in mind, it's a commercial hunting property. And you had a bunch of procedural motions that were filed in this, but basically you get down to all right, how do we put a value on those 156 mature trees? Well, one of the things the plaintiffs did, and this is what you cannot do, the courts will not allow this, is that he hired a couple of arborists to come out and tell him what those trees were worth in terms of replacement value. And they said, well, if you were to buy the trees from a nursery, now these are mature trees, so and they've been there 60, 70 years, the estimates were, you can't really replace those with 70-year-old trees. But if you were to replace them with mature trees and buy them on the market, that would be about $1.1 million. Now, the courts will not allow you to do that because the court in this instance said, now, wait a minute, that's going to triple the value of the ranch. That's not the point of damage calculations in these situations. So the point is we're trying to put the damaged party back to the position that they were in prior to the damage, not provide a windfall to them, and that would be a windfall. So you can't do that. And that's a point to keep in mind here. So the general measure of damages, here's where it comes down to, and what it comes down to in these cases, and the Kansas case follows cases from all over the country, is that you take the difference in the market value of the land immediately before and after the damage, and that's going to be the measure of your damage. But the court in Kansas said that's not an inflexible rule. That rule is flexible, and they said the parties can present evidence supporting an alternative measure or alternative measures of damages. So the trees have an independent value of the land. And again, you might have loss of income from fruit trees, you might have sentimental value of a tree, and the court said, we're going to entertain that type of additional evidence. So they kicked it back to the lower court, and they're going to allow that additional evidence to come in.
And you hit upon something I was going to ask, and maybe simple question, would sentimental value of a tree go under, like, my tree is beautiful, the aesthetics of the tree, my tree is 150 years old, I've had it, this has been in my family 3-4 generation type thing that you could claim?
That one depends. It depends on what the aesthetic value traces to. Maybe it's a tree, and you're going to have to prove all of this, and the courts will listen to it, is what the Kansas Court of Appeals is saying. It's not. I'm not saying that the court is saying that you can get damages for that, but they will entertain that, and they will listen to it, and it may be probative on the and relevant is what I mean on the issue of computing those damages. So let's say I know a number of years ago there was a really old tree over near Wamego. Well, let's say that it gets sprayed, and that old tree, centuries old tree, and you can remind me on, Greg, you probably know what I'm talking about. I think it recently died of natural causes. Mm-hmm. But let's say something negligent, somebody's negligent conduct damaged that tree. Well, whoever owned that tree would probably be able to recover for that because it is so unique. It was so old. Or let's say that you can prove that you and your great-grandfather planted a tree when he was 100 years old, and he died a year thereafter, and now that is a mature tree that is 45 years old. That's a pretty unique situation, and that was damaged. Then the issue is, okay, we will allow you damages for that. Give us some value of what that's worth, and let the courts consider it. So we've got this before and after rule, but the court says that's not a hard rule. That's not inflexible. So if you can prove up your damages, you might be able to get something for those aesthetic values. Now, if we're talking trees that produce things, then we get into the economics of it. You can show what your production was from those trees in prior years. You can show what it's not now, and we kind of have a stream of income loss that we can value and factor that in. But often we're not dealing with those types of producing trees that produce fruit, vines that produce grapes, for example. We get into these windrow type trees in Kansas, and it's a little tricky to prove what the value of those are.
Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, joins us, and we've got some cases to talk about here. Roger, first, let's talk about a nuisance case, and this is concerning confined animal feeding operation, in this case, a hog CAFO that continues.
Yeah, this is down in North Carolina, and Greg, over the past few years, there have been a number of nuisance lawsuits filed in the state of North Carolina, all involving the state right to farm law. And these cases have involved Murphy Brown, which is a subsidiary of Smithfield Farms, which is now China-based. They're owned by the Chinese, and that became relevant in this case. That fact tried to be dismissed by the defendants as prejudicial against them, but the court said no. That is relevant in terms of how much money you have that you could use to remedy these problems, and other factors going toward its operations. But the plaintiffs in this instance, landowners, sued Murphy Brown for trespass, negligence, civil conspiracy, unjust enrichment, a whole bunch of things arising from all of the odors and the dust and the feces and the urine and flies from a neighboring hog facility. And this wasn't just your mom and pop hog facility. This is a 20,000 head CAFO, a confined animal feeding unit, containing hogs. And they wanted not only compensatory but punitive damages. And, of course, there were procedural moves. The hog operation tried to get it moved for various procedural defects, but the court said we're going to let this go through. And they had both nuisance and non-nuisance claims, and they tried to argue that the right to farm law would bar pretty much bar all of these claims. And the court said no, not this state statute. It's unlike some other state statutes where the nuisance law will also bar some non-nuisance types claims. And the court said, look, it's reasonably foreseeable that the operator of the CAFO did not act reasonably in managing the facility, and dust and animal waste could be present on the plaintiff's property as a result of that. And so they said, again, there's a duty to act in a certain way. They breached the duty. It caused damages to the neighbor, and the plaintiffs have made out all of the elements to a negligence case, even in light of the fact that there's a right to farm law that protected or purported to protect that confinement operation.
One I want to jump down to before we run out of time is another case concerning the former President Trump and his ruling on the Navigable Waters Protection Rule in a case involving the state of Colorado, and where that rule applies in all states.
Well, yeah, the state of Colorado had challenged the implementation of the WOTUS rule. And, of course, this is a reversal of the Obama-era rule, which was much more restrictive on what happened on private property and gave the federal government more jurisdiction over private property. Trump administration changed that around, and then, of course, it was challenged by environmental groups in some states. Well, what happened just recently was that the Colorado Federal District Court entered a preliminary injunction barring the Navigable Waters Protection Rule, that's the Trump rule, from taking effect in Colorado. But the appellate court turned that around, and they said, no, Colorado, you didn't show the irreparable harm without the issuance of that preliminary injunction. So what that means is that National Water Protection Rule under the Trump administration is now in effect in every state in the United States. But the litigation is going to continue on that, Greg.
Yeah, absolutely. And this next case, 100-plus-year-old case. So you're thinking, well, what does that mean? Well, this involves a fence agreement and the boundaries that it had.
Yeah. Well, I've been telling farmers and ranchers for years, it's always best to get your boundary fences under an agreement. Put it in writing in terms of who's responsible for building and maintaining that fence if it gets into a state of disrepair, so that we don't have disputes over this stuff. Well, somebody did that back in 1914 down in Texas. They actually executed a fence agreement. However, the problem was they used a meets and bounds description. Now, what that is that's a description form that's pretty common in the eastern third of the United States. It prevails heavily east of the Mississippi. You hardly ever see it out here and in Texas. And what that means is we're going to describe property by references to boundaries, boundary markers, or monuments, or trees, for example, or a stream, or you might see a golden spike found at such and such a distance. And what you do is you walk in a certain direction to that monument, you turn in a certain direction, according to the description, and then you close out the circle doing that. Well, what happened, the agreement was put in place in 1914, and the monuments referred to in the fence agreement 100 years later, when this came up in terms of a dispute between the landowners, they couldn't find the stuff referred to in the fence agreement. So now we got the problem again. But the court said, I think there's enough in here, the court said, even though it referred to non-permanent markers in the 1914 fence agreement, that we can't find it. We think we can't find those things anymore. We think there is sufficient evidence to support the defendant's claim of ownership of the disputed acres, which was quite a bit in this instance, in accordance with the 1914 fence agreement. The lesson out of this one is, good job on getting the fence agreement down. Be clear on what you're referring to. Try not to use meets and bounds. Use a survey-type description.
I know we're going to run a little late here, but another one that I want to get to before we're at the end of the program, a boundary by acquiescence established by the Landowners Conduct.
Yeah, and we get into this a lot in agriculture on boundary issues. So can we establish a boundary just based on the way that the parties the adjoining parties use the property? And the answer is yes. If you do it for a long enough period of time, that might be 15 years in Kansas, might be 10 years in Iowa, it might be 2 years in other places, might be 7 years in Montana, for example. But that's what happened in this instance. They claimed that, well, there was an existing line, and the parties treated that line as the boundary, and that did become the true boundary. So what you can do in those instances is you can file what's known as a quiet title action in the local court, the county court, district court, whatever it's called in the jurisdiction, and have the court deem the way that you've been treating the properties by the adjacent landowners as the legal boundary, irrespective of what a survey says.
All right, Roger, we're out of time, but as always, appreciate it, and we will talk to you here in a couple of weeks.
All right, thank you, Greg.
That is Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law. He joins us on the Ag Issues program here on 580 WIBW.